Hello viewers, I am Dr. Simranjeet Kaur, Professor and Principal School of Law, City University, Ludhiana, Punjab. Welcome to this lecture on theory of justice and its correlation with the law. Justice, often referred to as the cornerstone of the civilization, is essential to the functioning of any society. This session will explore various interpretations of the justice, its importance in governance, its relationship with the law, and key theories proposed by the prominent philosophers. As we delve into this topic, we will examine how justice shapes societal norms and influence the legal framework, highlighting the complexity of the maintaining fairness and order within the state. By the end of this lecture, participants will be able to define and understand the concept of justice and its evolution over the time. Examine the importance of justice in the context of the state governance and the legal system. Analyze the relationship between justice and the law, highlighting how judicial systems strive to administer justice. Explore different theories of the justice such as Aristotle's idea on distributive and corrective justice, egalitarianism and utilitarianism. Correlate these theories with the contemporary legal applications. Participants will gain a comprehensive understanding of the key justice theories and their societal implications. Recognize the nuanced relationship between the justice and the law in the legal system. Develop critical thinking on the role of justice in the legal and administrative decision making. Be able to apply theoretical perspective to contemporary issues of justice and the law. So let's start with the theories of justice and its correlations with the law. The most essential functions of the states are primarily two. The one is war and the administration of justice. If a state is not capable of performing either or both of these functions, it cannot be called a state. According to Salmond, the administration of justice implies the maintenance of right with political community by means of the physical force of the state. Justice is the first virtue of the social institution, as a truth is the system of thought. The main idea of the theory of justice is to present a conception of justice which generalizes and carries to the higher level of abstraction the familiar theory of the social contract as found, say, in the Locke, Rousseau, and the Kant. In order to do this, we are not to think of the original contracts one to enter a particular society or to set a particular form of government. Rather, the guiding idea is that the principles of justice for the basic structure of the society are the object of the original agreement. They are the principles that free and rational persons concerned to further their own interest would accept in an initial position of equality as defining the fundamental terms of their associations. These principles are to regulate all further agreements. They specify the kind of social cooperation they can be entered into, the form of the government that can be established. Now let's discuss what is justice. Justice is a concept of the moral rightness based on ethics, rationality, law, natural law, religion, fairness, or equity, along with the punishment of the breach of the said ethics. Justice can be thought of as a distinct form and more fundamental than benevolence, charity, mercy, generosity, compassion. Justice has traditionally been associated with the concept of fate, reclamation, or divine providence, that is, with the life in the accordance with the cosmic plan. The association of the justice with the fairness has thus been historically and culturally rare and is perhaps chiefly a modern innovation in the Western societies. Importance of the justice. In the words of Professor Sidgwick, in determining a nation's rank in political civilization, no test is more decisive than the degree in which justice, as defined by the law, is actually realized in its judicial administration. Lord Bryce writes, there is no better test of the excellence of the government than the efficiency of its judicial system. George Washington said, administration of justice is the firmest pillar of the government. Law exists to bind together and the community. It is a sovereign and cannot be violated with the impunity. Salmon and the Roscoe have emphasized the importance of justice in their definitions of the law. They have defined law in the term of justice. According to the Salmon, law may be defined as the body of the principles recognized or enforced by the public and regular tribunals in the administration of justice. Blackstone wrote, justice is not derived from the king as his free gift, but he is the steward of the public to dispense it to whom it is due. He is not spring, but the reservoir from whence right and equities are conducted by a thousand of channels to every individual. Justice according to the law in the modern times. What is given by the courts to the people is not what can really be called justice, but merely justice according to the law. Judges are not legislators. It is not their duty to correct the defective provisions of the law. Their only function is to administer the law of the country. They are not expected to ignore the law of the country. It is rightly said that in the modern state, the administration of justice according to law is commonly taken to imply recognition of the fixed rules. Law may be blind and therefore justice becomes blind, but there is no help for it. Judges are expected to give justice according to the law of the country and not according to what they consider to be just under the circumstances. Now let's discuss the variations of the justice. Utilitarianism is a form of a consequentialism where punishment is a forward-looking, justified by the ability to achieve future social benefits resulting in crime reduction. The moral worth of an action is determined by its outcome. Retributive justice regulates proportional response to the crime proven by the law, full evidence so that the punishment is justified, imposed and considered as morally correct and fully deserved. The law of retaliation, lex talionis, is military theory of retributive justice, which says that reciprocity should be equal to the wrong suffered. Life for the life, wound for the wound, stripe for the stripe. Restorative justice is concerned not so much with the retribution and the punishment as with making the victim whole and reintegrating the offender into the society. This approach frequently brings an offender and a victim together so that the offender can better understand the effect his or her offense had on the victim. Distributive justice is directed and the proper allocation of the things, wealth, power, reward, respect among different people. Oppressive law exercise an authoritarian approach to the legislation that is totally unrelated to the justice. A tyrannical interpretation of the law is one in which the population lives under restriction from the unlawful legislation. Now, let's discuss the relationship between the law and the justice. The term most frequently used by the lawyers in the praise of the condemnation of the law or its administrations are the words just and unjust. And very often they write as if the ideas of justice and morality were coextensive. There are indeed very good reasons why justice should have the most prominent place in the criticism of the legal arrangements. Yes, it is important to see that it is a distinct segment of morality and the laws, and the administration of the laws by have or lack the excellence of the different kinds. Very little reflection on some common types of the moral judgment is enough to show this special character of justice. A man guilty of the gross cruelty to his child would often be judged to have done something morally wrong, bad, or even wicked, or have disregarded his moral obligation or duty towards his child. But it would be strange to criticize his conduct as unjust. This is not because the word unjust is too weak in condemnatory force, but because the point of the moral criticism in the terms of justice or injustice is usually different from the more specific than the other type of the general moral criticism which are appropriate in this particular case and are expressed by the words like wrong, bad, wicked, unjust would become appropriate if the man had arbitrarily selected one of his children for severe punishment than those given to the others guilty of the same fault, or if he had punished the child for some offense without taking step to see that he really was the wrongdoer. The just and unjust are the most specific for moral criticism than good and bad or the right and the wrong is the plain form of the fact that we might intelligibly claim that a law was a good because it was just, or that it was a bad because it was unjust, but not that it was just because good or unjust because bad. There is a certain complexity in the structure of the idea of justice. We may say that it consists of two parts: a uniform or constant feature summarized in the precept treat like cases alike, and shifting or varying criteria used in determining when, for any given purposes, cases are alike or different. But this determination is far complicated when justice is concerned, because the shifting standard of the relevant resemblance between the different cases incorporated in it not only varies with the type of subject to which it is applied, but may often be opened to challenge even in relation to the single type of subject. In certain cases, indeed, the resemblance and the differences between the human beings which are relevant for the criticism of the legal arrangement as just or unjust are quite obvious. This is preeminently the case when we are concerned not only with the justice or injustice of the law, but of its implications in the particular cases. The connection between this aspect of the administration of justice and the very notion of proceeding by the rule is obviously very close. Indeed, it might be said that to apply a law justly to the different cases is simply to take seriously the assertion that what is to be applied in the different cases is the same general rule without prejudice, interest, or caprice. Theories of the justice. Aristotle and the theory of justice. According to the Aristotle, distributive justice means injustice arise when equals are treated unequally and also when unequals are treated equally. Aristotle contrasted distributive justice from correlative justice. According to Aristotle, distributive justice is the distribution of goods and honors to each according to his place in the community. It is conceives equal treatment of those equal before the law. The corrective justice is the measure of the technical principles which governs the administration of the law in regulating legal relations. Correlative justice imposes an obligation that uniform and general standards should be laid to measure the standard of redressing the violating of the law, notwithstanding what the position of the individual is. Egalitarianism. According to the egalitarian, justice can only exist within the coordinates of the equality. This basic view can be elaborated in many different ways according to what goods are to be distributed, wealth, respect, opportunities, and what they are to be distributed equally between individuals, families, nations, races, species commonly held. Egalitarian positions includes demand for the equality of opportunity and for equality of outcome. It affirms the freedom and justice without equality are hollow, and that equality itself is the highest justice. Utilitarianism. A society according to the utilitarianism is just to the extent what its law and institutions are such as to promote the greatest overall or average happiness of its members. How do we determine the aggregate or overall happiness of the members of the society? This would seem to present a real problem, for happiness is not like temperature or weight, directly measurable by any means that we have available. So, utilitarianism must approach the matter indirectly. The traditional idea at this point is rely upon a theory of the human good, that is, for what is good for the human beings or what is required for them to flourish, and an account in the social conditions and the form of organizations essential to the realization of that good. So, according to utilitarianism, the just society should be so organized in its institution, its governments, its law, its economy, that as many people as possible shall have the means and opportunity to achieve their chosen conception of the desirable life. To reform the institution of one society towards this goal in the utilitarianism view is to pursue greater justice. Some of the institutions that utilitarian have championed over the years are a public education system open to all and funded by the public money. What is taxes? A competitive free market economy in the 19th century, utilitarianism are often argued for the laissez-faire capitalist economy. More recently, some of them have argued for the mixed economy, that's the state-regulated market system. Mill interestingly argued at the beginning of the 19th century for an unregulated capitalist economy, but at the end argued for the social economist, which is not the same thing as the mixed economy. The protection of the sort of the liberties that were granted in the United States by the Bills of the Rights in our Constitution, democratic form of the government generally, justice as fairness by the John Rawls. One of the most interesting modern attempts to defend the principle of justice is found in John Rawls' theory of justice, as now formulated in the political liberalism. The conception of justice for which Rawls argues demand the maximization of the liberty subject only to such constraints as are essential for the protection of the liberty itself. Equality for all, both in the basic liberties of the social life and also in distribution in all other forms of the social goods, subject only to the exceptions that inequalities may be permitted. It may produce the greater possible benefits for those least well off in a given scheme of inequality, the difference principles, and fair equality of the opportunity and elimination of all inequalities of opportunities based upon birth, wealth, his magnus opus. A theory of justice is now regarded as one of the primary texts in the political philosophy. His work in the political philosophy, dubbed revisionism takes as its starting point the argument the most reasonable. Principles of justice are those everyone would have accept and agree to form a fair position. His theory is known as justice as fairness, from which Rawls derives his two famous principles of justice, liberty principles and difference principle. Rawls and the first principle of the justice. First, each person is to have an equal right to the most extensive basic liberty compatible with the similar liberty for the other. Role and the second principle of the justice. Social and economic inequalities are to be arranged so that they are to be of the greatest benefit to the least advantaged member of the society. The difference principle. Offices and positions must be open to everyone under conditions of the fair equality of opportunity. Justice as entitlement. Nozick. Robert Nozick's Anarchy, State and Utopia is one of the most provocative essays in political philosophy in the recent times. In it, he revives the claim long associated with John Locke and Herbert Spencer that a minimal state limited to the narrow functions of the protection against the force, theft, fraud, enforcement of contracts, and so on is justified, and that the minimal state is inspiring as well as the right. He develops a conception of justice which he calls entitlement theory, according to which economic goods arise already encumbered with rightful claims to their ownership. Philosophies which espouse distributivism or worse, redistributivism are misconceived. Nozick extols the virtue of the 18th century individualism and 19th century capitalism, and it may be have a thought to have captured the character of the Thatcher-Reagan's era. Even so, it came as a profound shock for many. First, Nozick seeks to justify the minimal state against the individual anarchist who holds that when the state monopolizes the use of the force in a territory and punishes others who violate its monopoly, and when the state provides protection for everyone by forcing some to purchase protection to the others. It violates moral sides, constrain on how individual may be treated, thus concluding the state itself it's interestingly immoral. To the Nozick, what is attractive in this scenario is that the state grows by an invisible hand process and by morality. Permissible means without anyone's right being violated. Justice as a right. Ronald Dworkin. For both Rawls and Nozick, there is a clear relationship between the justice and the rights. But it is Ronald Dworkin who can be said most clearly to ground justice and right. In one sense, there is nothing new in this idea that a political morality and the social choice were to be governed by the consideration of the rights of the individuals, as it is the heritage in the writings of the Locke and Kant, as well as in the literature and the constitutions of the American and the French revolutions. The emphasis has not gone unchallenged. Bentham was a trenched critique, particularly of the natural rights. So was the Marx today. One of the central conflict in the legal, moral, and political philosophy is between those who espouse right-based theory and those utilitarianism in particular, who put forward those goal-based theory. The distinction is easy enough to the state. A requirement is rights-based when generated by the concern for some individual interest, and goal-based when propagated by the desire for further something taken to be of the interest to community as a whole. The rights-based approach does not deny that the interest of a particular individual is not also shared by the others in the case of the human rights in the community, but it would claim that the interest of each individual, qua individual, is sufficient to generate the moral requirement. It is a part of the philosophy of those who espouse the right-based theories to insist on the preeminence of the rights. Rights are valuable commodities, important moral coinage. Saint Thomas Aquinas and the theory of justice. His concept of justice was to correlate positive law with the law of God, as he believed that justice is taken away, the kingdoms are reduced to the robberies. Justice has been defined by Saint Thomas Aquinas as the habit whereby a man renders to each one his due by constant and perpetual will. Justice is the steady and the lasting willingness to give to the others what they are entitled to. Aquinas works with this Roman law definition and the Aristotle's division of justice into the distribution, good judgment about how to divide up and parcel out beneficial or burdensome, wholesome or sets in a way what is fair because guided by appropriate criteria, and what Aquinas called commutative justice, good judgment going for wider than Aristotle's corrective justice, and concerned with all kinds of dealing between persons, his prioritizing of the concept of the right, which is called as jus, conceived as something that belonged to another, bringing him to the brink of articulating a concept of human rights, a concept certainly implicit in his thesis that there are precepts of justice, each imposing on me and my communities, a duty to everyone without discrimination. For his definition of justice immediately entails the correlative to such duties of the justice, there might be rights that belong to everyone indifferent. Cicero and the theory of the justice. Marcus Tullius Cicero, a Roman orator, equated justice with the universal natural law principle of the divine origin, and accordingly justice means equality of men in terms of discovering the divine truth. Justice is an essential condition for the human welfare and freedom. According to Cicero, there are three types of the government: monarchy, aristocracy, and the democracy. Cicero says that the law is the means of achieving just government. Men are slaves of the law to achieve the freedom. Freedom means freedom from the arbitrariness, and the power should not be abused. In concluding remarks, we have reviewed various theories of the justice, the reformulation of the utilitarianism we saw comes from the John Rawls, who did not present it as a version of utilitarianism at all. He presented it as a first approximation to the quite distinct concept of justice from utilitarianism, a concept that he calls justice as fairness. It is one of the most interesting modern attempts to defend principles of justice. One cannot think about justice without taking a position in Rawls' theory of justice. In a world where people are interconnected but they disagree, institutions are required to essentiate the ideals of the justice. These institutions may be justified by their approximate instantiations of the justice, or they may be deeply unjust when compared with the ideal standards. Consider the institution of slavery. Justice is an ideal the world fails to live up to, sometimes despite good intentions, sometimes disastrously. The question of institutive justice raises issues of legitimacy, procedure, codification, citation, interpretation, which are considered by the legal theorists and by the philosophers of law. Another definition of justice is an independent investigation of the truth. In a courtroom, lawyers, the judge, and the jury are supposed to be independently investigating the truth of an alleged crime. In physics, a group of physicists examines data and theoretical concepts to consult on what might be truth and reality of phenomena. Thank you for your attention. I hope this session has provided valuable insights into the correlation between justice and the law and how foundational justice theory remains relevant in today's legal landscape. Thank you.